Are you worried about who will take care of your loved one if they become incapacitated, or worried about that for yourself? Well, in today's video, I'll guide you through the guardianship process for incapacitated adults in Georgia, helping to ensure that they get the care and protection they need. Hi, I'm estate planning attorney Mike Smith with Smith Barid LLC, and I'm one half of the estate planning guys. So let's start by understanding what guardianship is. Guardianship is a legal process where the probate court appoints an individual to care for someone who is unable to care for themselves due to incapacity. So the legal standard is this person, what's called the proposed ward, able to make significant responsible decisions for themselves in the case of a guardianship regarding their health and welfare, or with a conservatorship about their finances. So I'm going to use the generic term guardianship, but I'm referring to both a guardianship and a conservatorship with that term. In Georgia, we split those into two separate things. Guardians take care of the person, conservators take care of the money. But generally, we're going to file a petition that covers both of those in one petition. So why is that important? Well, without a guardian, an incapacitated adult may not have anyone to legally make decisions for them on their behalf. And this can lead to neglect in some cases or financial exploitation. So let's dive into the steps that are involved in the guardianship process, and we'll kind of go through those one at a time. So first, a concerned party, often some family member, frequently can be a child or a spouse, must file a petition for guardianship with the probate court in the county where the incapacitated person resides. Or if they're in a nursing home, then in the county where they resided before they went into the nursing home. The petition has to include a detailed explanation of why guardianship is necessary and provide some evidence of the person's incapacity. And it requires that two family members sign off on it, and that you have two other adults who are somehow known by the ward. The person who needs the guardianship is referred to as a ward. So two other adults who know that person, and just to make sure that there are at least 4 people that are getting notified about the filing of the petition for guardianship conservatorship. After the petition is filed, the court reviews the petition, and if the court determines that there is probable cause for this person to need the appointment of a guardian or conservator, then they're going to schedule an evaluation by a clinical psychologist or a social worker. And that person is going to go meet with the proposed ward and make a determination about what their opinion is with respect to their ability to make significant responsible decisions for themselves. So that generally consists of some cognitive testing and just a general discussion about what's going on with that proposed ward. And the evaluator then prepares a report for the court that spells out what their opinion is. It'll give all the details of the meeting, and then at the end it'll say, here's my opinion, this person needs to have a guardian or conservator appointed, or they don't. And a copy of that is provided to everybody involved. So the petitioners will get a copy of it, and then the proposed ward will get a copy of it as well. The court then reviews that evaluation, and if the court still believes that there's probable cause for the need to have a guardian or conservator appointed, then the court will schedule a hearing. And the purpose of that hearing is to determine first if there is evidence to support that the proposed ward needs to have a guardian or conservator appointed. In other words, can make significant responsible decisions for themselves. And secondly, to determine who should be appointed as the guardian or conservator. So at that hearing, if the ward is opposed to the appointment, then they can appear. They are also appointed an attorney to represent them. So the proposed ward has an attorney who is appointed by the court to represent them. And they can show up and provide their own evidence if it's a situation where the proposed ward has no opposition or is not in a position to oppose, then their attendance at the hearing can be waived. And at that hearing, the judge will hear evidence about the jurisdictional issues, about the ward's condition, and then we'll make a determination about whether the ward is capable of making significant responsible decisions for themselves. And if not, we'll then appoint a guardian. And in most cases, there's no opposition and the person who filed the petition will be appointed as the guardian. In some cases, a family may end up having a dispute about who should serve as the guardian or conservator, and then there can be evidence presented on that, and the judge will make a determination about who should serve in that capacity. So if you're interested in learning more about how we help families protect their legacies from probate, predators, and government intrusions, I wrote a free book titled The Ultimate Gift that lays it all out. If you'd like to pick up your free copy of The Ultimate Gift, simply click the link below, give us your address and a credit card for shipping and handling fees, and we'll ship it out to you free of charge. Read The Ultimate Gift so you can learn how to protect your family. What if you want to make sure that you have a choice about who's going to serve as your guardian? Well, there's a pretty simple way to do that. On the Advance Directive for Healthcare, which is a document that I think everyone should have, it allows you to appoint a healthcare agent to make medical decisions for you. And then it also allows you to tell the probate court, this is the person that I want to serve as my guardian or conservator if I need one. If you have filled out an Advance Directive for Healthcare, then you're telling the judge, this is the person I want to take care of me. And that has precedence, that has preference under the Georgia Code. That Advance Directive for Healthcare is in first place for who's going to be appointed as the guardian. Next, it goes to spouses, then it goes to children, siblings, etc. There's a list of who's preferred in that position. So I would advise you to prepare or to have someone prepare an Advance Directive for Healthcare for you and make sure that you select who you want to serve as your guardian if you should need one. Somebody that's capable of managing your personal and medical decisions or your financial matters if you need to have someone appointed. So once the guardian is appointed, then they must file a report within 60 days with the court, and there's separate reporting for the guardian and the conservator. I know it's really confusing. The guardian must file a report within 60 days that gives the court an update on the ward's condition, as well as a plan going forward for how they're going to be cared for, where they're going to live, who's going to provide the care, etc. And then the conservator, the person responsible for the money, has to file a budget with the court that's sort of a financial plan for the next 12 months, as well as an inventory of the assets and liabilities of the proposed ward. That all has to be filed within 60 days, and then once a year after that, so every 12 months after that, there's an ongoing responsibility to file that. And then one other thing to be aware of is that if you are appointed as a conservator, then you are going to have to post a bond. And the judge sets the bond. It's typically going to be something that represents sort of the entire estate and 1 year's worth of income. And the purpose of that bond is to make sure that if the conservator doesn't do the job right or tries to run off with the money, that the ward is protected. So that bond is in place to protect the ward. And that bond you get through an insurance company, and they typically have some sort of premium that you pay. Typically, it's going to be in the range of $1,000 to $1,500 a year in premium that you pay to have that bond in place. But that's just protection for the ward to make sure that the conservator, if they stole the money, that there would be a protection there for the ward. So we see these types of situations often with folks who develop dementia and they're unable to make good decisions about their finances and their medical care anymore. And oftentimes the children are going to be the ones that petition the court to ask for the guardianship, conservatorship. It can be a lengthy process. It just kind of depends on what the load is at the court as to how quickly it occurs. You know, the evaluations have to be done. There have to be hearings, you know, that sort of thing. So it can take some time to get someone appointed. If you need help with appointing a guardian for an incapacitated adult, or you have questions about the process, you can visit our website or book a consultation with us using the link in the description. We help families with these sorts of matters all the time, and we'll be happy to assist you if you need help. If you found this video helpful, check out the next video on how to create a comprehensive estate plan. I'm sure you'll find it very valuable. I'm Mike Smith with the Estate Planning Guys.